Good morning, gentlemen. This is the regularly scheduled meeting of the Collection Service Board. If we may, since Mr. Howard has already called us to order, we'll just go ahead and read the notice of meeting, and then we'll jump in from there. Notice of February 13th, 2019 meeting of the Collection Service Board meeting was posted to the Collection Service Board website on February 4th, 2019. And we'll go ahead and look at, I suppose that everyone's looked at the agenda. Is there any amendments to that or any comments in regards to that? Okay. If we can have a motion to accept that.
So moved.
All right. Thank you. And then we have a motion from Mr. Holden. We have a second from Mr. Harb. All in favor?
Aye.
All right. That has passed. We'll accept the agenda as it is then. We'll move on to December minutes. I'll give you a moment to drum that up on your iPads and take a look at that, and then I'll wait your comments.
All right.
Unless there's any other comments, if we'll entertain a motion in that regard then, to accept then. Anyone would like to provide that motion?
Motion to approve minutes as
All right.
presented.
We have a motion from Mr. Harp, and we have a second from Mr. Holden. All in favor?
Aye.
All right, thank you. That's passed then. Move on to the director's report. All right, well, we'll just jump right in the budget. I think you'll be pleased to see the numbers on this. I was looking forward to going over this. Your hard work from last year to deal with some of the legal costs that we had with the agreed citation order, and then with the arrangement we had three prongs when dealing with the referrals, referring to our SOP, and of course those things that were anonymous, closing those as well, opening and then closing those has been a benefit to us. All right, on with the budget then. We of course took that three-prong attack to the I think the exploding legal cost, and by SOP we weren't we no longer referred those things that weren't within our scope or capacity, or when I say capacity I mean scope or mission mandate. We also dealt with anonymous complaints, things that had nothing actionable on that, and then the agreed citation schedule. So I think you'll see that we plugged those holes. If we look at the fiscal year for the last 4 years, I'll give you an opportunity to look at some of the expenditures. You've got the expenditures on top, and then you've got the revenues at the bottom, and then the final balance carrying over. You've got the grand total of expenses right there in the center. And then all those things are itemized there within Edison. To the left, you'll see those accounts for which those expenditures are coming out of. But about $46,000, and then you've got, in addition to that, the cost backs such as administration, investigation, legal, field enforcement, customer service center. And of course, we've discussed what administrative cost backs are. That's basically your share of all the programs expenses that aren't otherwise itemized in Edison. They have the same accounts, but sometimes they don't neatly fit into Edison. So for example, we share one building together. Well, how do you break that down? Well, they look at number of licensees. They also look at the program budget and the complaints. With us reducing our complaint footprint by dealing with that administratively with a lot of those, we'll also see a reduction in administrative cost backs as well. So that's what that is. We've discussed that before. And, of course, investigation, anytime inspections or field enforcement goes out, or we send an investigator somewhere, that's going to be that there's a cost to that associated. And, of course, legal expenses, which is the a big portion of that as well. Total expenditures, 196,000. You look at the revenue a little further down, and the revenue, net revenue, was 194, which left us of last year a fiscal deficit of 1,500 carrying over, which was moderate compared to we got nearly $700,000 in reserves. However, if you go to the third page, let's just go over there. We'll skip that second page and come back to it. You'll notice that we're tracking with the net surplus all the way across the board. That wasn't the case last year, but we've since plugged that hole, so we're looking pretty good. So we're back on track where we need to be. If you look at we'll just hit some of the big numbers. Let's look at December. That revenue is a little bit higher than the others. We have a renewal cycle. That's of course 2 years based on each of the licensees, but December is a little bit more heavier typically for each and every year. So, which is the case here. We expected that, so that we got a nice little boost there. And then of course that leaves us with a surplus of 32,000 for the month of December. If you carry that over, we've got a surplus of 77,000 for the year, and we don't see any reason why that trending wouldn't continue. Of course, that will bring us to the next issue, but it's a little bit more down the road. When it comes to sunset hearings, the legislation's always looking at your reserves. None of the programs are necessarily in the business of building and boosting their reserves. So if it continues in that upward trend, then we'll address that at that time and decide what we need to do as far as maybe reducing revenue at that point. And there's usually ways to do that, and that's typically through licensing fees. And so we'll discuss that when we get there. Right now, though, we're looking good. The second page is your administrative cost backs. I alluded to what that was, just to give you an idea of total share. Administrative cost backs, right where it turns green there, it's right in the center. That's your total administrative cost backs of 150,000. If you look to the column next to that, the percentage of all the programs, that comes just under 2% of all the programs. So basically, out of near $8 million of expenses, this program bore $150,000 of that. Whereas, Cosmo and Barber, they're looking at about 16% of that, so which would be exponentially larger than what we bore because of the size of licensees as well and their complaints. So, so far so good. And of course, the program share of that's always adjusted based on as the licensee pool grows, or as the complaints may rise, then that percentage could vary. But it's not going to be much with this program. I don't foresee we end up with 1,000 licensees tomorrow. So I think we're going to stay probably within that percentage. Any questions on that?
When does the state actually come and get the money from us? When I can't remember what they call it, administrative costs, I guess.
Yes, sir.
Is that at the end of the year or middle of the year, June?
They do that. They make adjustments. It's not quarterly, but it's typically the end of the year, and then usually about the middle of the fiscal year as well. Yeah. Of course, that'll show up in the trend. So when we get there, that'll reflect when we get that third page. When it shows the trending, it'll pop up. It'll show up there. And typically, when you see an exponential increase there, that's why. And you'll notice in the Ministry of Cost Backs, they track those throughout the year. So you'll see that trending. But when they do maybe a program, for example, if they do a big core enhancement dump like they did recently, then they spread that across in nearly into the fiscal year. So that's typically when you see that. But you'll notice too that most of that's tracking throughout the year already. It's not like just quarterly where you have nothing taken out and then they hit you with it, at each quarter. They take it out throughout the year based on that percentage. And then they'll make a correction at the end of the year if it looks like you had less complaints or less licensees, you lost licensees, or you gained them, and then that's where you'll see that correction at the end of the year. Any questions?
I think if we're at this place in the agenda, we talked last meeting about the recovery rate for the fines and costs that we've been finding agencies. And we looked at some percentages, and it looked like we were collecting about 8% of what we would fine them. $8,800 versus $1,700 in collections, something like that. I don't see these numbers on there. Have we increased that, or do we have a way of tracking that income now?
We track that income. We just have to pull it from the report. But it looks like, yeah, all matters requiring collection efforts over 10,000 referred to the Attorney General's office. But I made some notes to myself here as well. Yeah, it looks like the strata, the scheme that's being used, or that facilitates those collections efforts, are decided outside levels of, or outside of the board. It's not. That's really a process or a scheme that's really developed by administration. Outside fiscal and administration. That'd be more in their purview, and then that's passed on to us as a department. That's not something that typically, at our level, that we'll be able to influence, at least in the immediate. I mean, we can send up our comments and they'll take those into consideration, but unfortunately, that's not something that we have a lot of autonomy with.
Action when they don't pay? Do we actually pull their license for non-payment?
That's going to happen with the new agreed citation. If you recall, that was something that we wrote into this agreed citation. I don't know if it was the last meeting, but one of the recent meetings, if you remember, Ms. Hoover helped us craft some of the language in regards to that. And then our disciplinary council added that to the agreed citation, and that was immediate. So every that day going forward, whether it was the last meeting or the one before that, that will be a penalty. It's automatic suspension, voluntary suspension of that license for non-payment. Of course, those are those that sign and agree to that citation.
Those are for licensed agencies. Okay. Unlicensed agencies, nothing happens to those guys.
Well, I wouldn't say nothing. It's a little bit more difficult to collect, on unlicensed folks. But there are levers that are pulled, and if we get into the deep dive part of that, I'll of course defer to legal to answer some of those questions. But no, they are. There is an attempt to collect.
I think that my consideration is that we have licensees that we're administering the rules and regulations. Some we fine for doing things wrong, and some we don't. Anything wrong, obviously we don't fine them. But the ones that pay their fine those guys are fine, but it's the ones that don't pay their fine, it seems to me they're thumbing their nose at the ones that do. And it doesn't seem fair for somebody to be fined for doing something, and then we don't have any, we don't do anything to collect the money or enforce the fine.
Well, I don't think they're thumbing their nose at the ones that pay. I think they're thumbing their nose at the board.
Yeah.
And if they don't pay their fine and they're licensed, why don't we pull their license?
With the licensees, there's a property right attached to that license, and we cannot revoke it without a formal hearing to get a judge signed order if they have not signed that consent order. So those cases would be the ones that we have to go to hearing for to get an order that says we can revoke that license.
If we went to a hearing, is there any shortcut where we take it straight to a judge for non-compliance? Actually have to say, your hearing is set for this date. You don't show, and it goes. If they don't show for the hearing, then we can take it straight to a judge for.
Right, it would be a default judgment. So you would still have Dennis put on proof, and the board would still decide if the punishment you feel was revocation. You'd still decide to revoke the license at that time.
That's assuming that if it was unlicensed. I don't know if this board's ever kept those cases before them. So,
I was speaking about licensees, but
right, for licensees, exactly.
Licensee that doesn't pay.
Sure.
right.
Unlicensed activity, and we get a lot of that. A lot of our fines are for practicing unlicensed, and the agency is likely licensed in other states. They just don't happen to be licensed here. NMLS would help us track those and make that enforceable. What can we do if I own an agency and I'm in Minnesota and I get a fine from Tennessee for trying to collect debts down here, and I get it and I say, well, I'm not going to pay that, or I'm not going to sign the consent order, I am going to sign the consent order, but not send in the money. What do we have any recourse on those unlicensed?
I think if
Operators.
they're licensed in other states, we can always alert them that they've been found in violation of Tennessee law. At that point, of course, it's up to that state if they're going to take any action on that. But again, that's a matter of being able to identify what company that is and what state they're licensed in.
And I think my point is we don't do any of that. We just send out a consent order and tell them to sign it, send it back to us, and send in the money, and then that's the end of it. It's like getting a car finance, and the bank never calls you about making a payment. I wouldn't pay them either. Nobody made me.
Surprised that we don't take any action if they don't pay. A Tennessee
I don't know if that is quite the way that we would see it in legal. It's not that we aren't doing anything. If we don't have a signed consent order where they are admitting to that violation, we still have the burden of proving that they are guilty of that violation. What's being presented to you on a legal report is more of a probable cause hearing, but they haven't had the full opportunity to defend their side of the story. And so without a signed consent order, we have to go to formal hearing before we can take action on their license.
What efforts does it take to go to a formal hearing?
Well, first of all, instead of a consent order, we have what's called a notice of hearing and charges. I draft that, or whoever is in my seat drafts that. It's filed with Secretary of State's office, and then an attempt is made to serve them with the actual notice. And that can either be through regular mail, it can be through FedEx, or as we've had problems with out-of-state entities, sometimes finding exactly where to send them to, our investigators don't go out of state. So if we have to go out of state to serve someone, that usually requires some coordination with some service that potentially could serve the right person. Because the issue that the ALJ, that the administrative law judge is going to look at is that, okay, you're saying they're unlicensed, but I don't have any proof that we've actually served them with the notice, so I'm not going to, effectively, they'll just say, well, counsel, until you can show me that you've served them properly, we're not going to have a hearing. So, but if we do, if we have the proper service and the representative from the unlicensed agency doesn't show up, then we put on usually the executive director to explain a little bit about what the law is, and then we present the judge with usually an affidavit from the complainant saying, yeah, I got a letter from ABC Collection and on this date, and then and the executive director will confirm, no, there is no record of any license, and usually that's all that the ALJ will need to find an unlicensed violation. And then after that, an initial order is created, and then it's an initial order only for about 15 days until it becomes a final order. And once it becomes a final order, then essentially there's the respondent would have sort of sat on the rights, and there's no way to appeal it, because there is an appeal process beyond that to Chancery Court. And then if the amount is under $10,000, typically the AG's office, the Attorney General's office, usually doesn't take any action. So up in collections, I suppose, again, just on, instead of a consent order going to collections, now we have a final order going to collections, and it just attempts made to collect it. Whether or not they ever collect anything, who knows?
I saw a report, Glenn made it up for me, thank you, Glenn, that I believe we turned one account over for collection. Last numbers that I looked at, an Excel sheet, we had fined people $8,700 or $500 maybe, and we collected $1,700. Now there's out-of-state agencies that are not licensed here, or that may be a service station somewhere that's collecting money. Our ability to collect money from somebody out of state is probably difficult. The only thing we can do is, if they are licensed, is ruin their credit, or so to speak, or turn that licensee over to the regulators in that particular state to let them know that they didn't pay, which is that we're talking about. There are agencies that are licensed and operating in Tennessee that maybe they pay their fine. There's two types. They pay their fine and sign the consent decree. Those guys are good. There are some that sign the consent decree, or sign the decree but don't send in the money. Others don't do anything. And those are the ones that I'm particularly concerned about. I'm concerned about all of them, and I think we could probably work out something to do with these out-of-state folks. Most of our unlicensed activity is done by a licensed agency. They just don't happen to be licensed in Tennessee, and they have a reason to pay. It's a $250 or $500 fine. It's very little, and they don't want that on their. They don't want to have to tell their clients that they haven't paid a fine from Tennessee, and that's basically what we could do. How are we tracking we send them a consent decree and tell them to send in the money, but we don't get any money, or we don't get a consent decree? What is our process at that point, or where does it go from there?
So they have 30 days to sign the consent order. They can contact Dennis and try to negotiate some sort of settlement within the authority that you've given him to settle the case. After that 30 days, if Dennis has had conversation, there may be an extension of time given. If not, Dennis would proceed to file formal charges, and that's where it goes into what he was talking about, filing the notice of hearing, set it for a hearing date.
That's for in-state licensees. That's
for everybody.
For everybody.
Mm-hmm.
Right.
Okay. It'd probably be difficult to get somebody out of state in here to.
Right.
Somebody in state, we have some.
Right, and I know, and I stated the 30 days, and that is our normal policy. As Dennis was explaining, the hardest part is actually getting good service, because we can go to day 31 and file the notice of hearing and charges, but if we can't get that to the person to let them know that you've been set for a hearing, many times administrative law judges will not proceed with the hearing because we don't have proof that this person knows about it.
Can't do it with certified mail?
Well, that's assuming if somebody signs for the green card, sure. Sometimes there's a problem, though, with, well, counsel, how do I know this? I'm just playing the role of the ALJ. How do I know that this is the registered agent for service, or how do I know that someone with some authority knows that this has been received? If it's just a desk clerk, and then there may be some ALJs that may not particularly hold us to that high standard of proof, and we can then proceed with the hearing.
I think in all practicality, somebody got a certified letter from our regulatory agency here, that it would go further than just nowhere. I think somebody at the front counter would take some concern. What I'm saying is it just feels like we do nothing. We send it out, and then we go on to our next operation or our next business. We don't seem to do any kind of enforcement other than send out the consent order.
Well, I can say that I have not, in the year that I've been on the board, not on the board, but working with you all as the board, I haven't set any cases, because largely some of the ones that get old, they eventually send in the money. Now, those are the ones where we're just talking about a consent order, not where we've actually set it for a formal hearing.
I've been on the board since 2003, and I think we've had one trial or one hearing. So there's pretty much we can say we don't do anything. Send out the consent order, tell them to send in the money, sign the consent order, send it back, and if they don't, they just keep right on operating and keep right on doing what they're doing, and we're not enforcing our rules and our regulations.
Now, we have in the last 6 months filed one notice of hearing and charges that was unlicensed, but well, actually, we didn't settle because there was an exception with that one. That was a promissory note issue where that type of action wasn't considered collection. So I guess to be specific, there has been one file, but there was no hearing due to the fact that collection of promissory notes.
I don't know that I don't think this board has the authority to resolve this problem. I just want to bring it to the administration's. I just want the administration to know that we as a board are sitting here trying to do what we can do and enforce the rules and regulations, but we don't have any, we don't get to carry a stick.
Sounds like to me that the things that are the stick perhaps is the formal hearing. So I think could probably look at that piece would probably be helpful, and then maybe obviously I can't speak for departments or divisions outside of my purview. So we'll look. We're always looking at all of our processes, but then also service is an issue too, because I know with some of my other boards, proof of service can be just as rigorous as the actual testimony of record. I've sat in some local some hearings with some of my other boards where, depending on the administrative law judge, will ask a lot of follow-up questions about service. And those are with folks that are licensees local. Somewhere where we could send out an inspector for service, put it right in their hand. This gets a little trickier when you go to a company who has several holdings, that's out of state. That's where I think, so that's an issue too.
I would mirror what Glenn is saying, that that is a big challenge with our out-of-state respondents, is knowing where to send, for example, the certified mail. Or if we did hire the services of an outside process-serving company, knowing where to tell them. Now, process servers sometimes can be a little more creative, but
Well, there's out-of-state agencies and then there's in-state agencies. Out-of-state, I agree, it's an issue, unless we were members of the NMLS, and then that would go on their record, and I think that would be a regulating process if we ever go to that. The in-state agencies are the ones that I think we could do better. I don't know how we can do better because I don't know what the rules are or what this administration wants to do about those fines. So we're not collecting them.
We can of course communicate that. Now there will be with all of our departments some realignment with the new governor, and so we'll have to make those adjustments as well. But I've made notes of kind of what we've been discussing and some points to explore.
A lot of collection agencies in Tennessee that do business here would love to have that business. How to do that, but I think it's something that ought to be collected, and it's there for the grabbing. Next on the agenda.
Yes, Robert's Rules. It's that time of year again. Just really a matter of process. We've been using Robert's Rules this morning and since 2003, Bart, so we're all familiar with that. We use a modified version of Robert's Rules, but if that is something that the board would like to continue, then we just need a motion in that regard.
Yes, we do need to use Robert's Rules. I wouldn't know any other rules to use, so. Could we have a motion from the board to use Robert's Rules?
Motion to continue using Robert's Rules.
Second.
All in favor, say aye. Aye. Okay.
I was interested to see if someone would have an alternative process or procedure. I was going to take notes if they were. Nakara,
There is no rules. It works. It works. Obviously, there's no rules for collecting fines.
Yeah, there's no
So-
rules for that.
No rules. I like that. But
All right, well,
we've already
maybe
passed-
next year then.
We've already passed this.
All right. NACARA is the Regulatory Association. Bart and I went to that one a couple years ago. They had one recently, then the board approved for us to reattend. Executive management at the time deferred. But they're having another one this year in, let me pull it up. It looks like it's Santa Fe, New Mexico. I haven't seen the agenda yet, but it's pretty typical. They have something just for the regulators, and they also have a portion for the industry as well. And from that, we brought back considerations. We talked about maybe raising the bond limit. We talked about NMLS, and then that's borne some fruit here as well. Best practices, typically, we share some notes with other regulatory agencies as well. Try to get their help and spotlighting sometimes the laundry on the treadmill. Sometimes you're too close to the project, you don't see it, and it's really helpful to be aware of those developments as they come down. If that is something that you would like to continue to support, and there's one or two members that would like to attend that will be on September 16th through September 18th in Santa Fe. So. I don't have the agenda. I don't have much other than what I have to offer you here until the agenda comes out, and of course we can make that available. But it's pretty typical. I saw the agenda last year, the one we were initially slated for, and it was a follow up to a lot of the pieces that we brought back from the first. A lot of investigation type items. There was a lot of round tables, and I think out of the round tables, I found those, I can't speak for Bart, but I found those to be particularly helpful because some things would be brought forward that I didn't really consider about because they're not necessarily in our purview, but might be something that we would consider, in the future. I mean, we're not very big on the examination or the investigation piece. We don't have a mandate for that, but there's some things that perhaps we could borrow from what they do that would be would be an assist to our shop here. But unless you had some other comments.
Only that I think it's an excellent program and organization, and it's good for our state to know what's going on in the rest of the country. Last year, the administration didn't want us to participate, and I don't know how the administration feels about it now. I think Glenn would agree with me that just the conversations at the dinner table with other states and other regulators was very, very helpful, and some things that we could bring back to our state that makes it well worth the while. It totally depends on the administration. I think that this board would agree to send to once again if we're ready for a motion.
Yes, sir. Just if someone wants to nominate somebody, first of all, then we can take a motion from that regard. So if there's any nominations.
I'd nominate Bart to go on behalf of the board. And
Anybody else on the board that would be free to go, potentially Mr. Holden or Mr. Harb?
I can make it, but I would second Steve's motion. That would be fantastic to have a representative there.
So we have a motion, I guess, from Mr. We had a nomination, but do we have that in the form of a motion as well then for Mr. Harb? All right.
I'd like to amend the motion to include Glenn in the proposal to the administration, so the two of us could go.
We typically they'll allow one from somebody from staff or administration to accompany a
Okay.
board
if
member.
we're allowed two to go, then by all means, I'd amend my motion to include Glenn.
That be your second as well then?
Yeah, I'd second that, absolutely.
All right. All in favor then?
Aye.
All right. Thank you very much. That's passed then. And then, Mr. Chairman, I'll keep you updated as far as the details on that.
Okay,
as we
sure.
get that as well.
Yeah. And is, just as a question, is the NMLS opportunity gone forever, or now that with a new administration, do you think we can bring that back to the?
I wrote that down actually in one of the because that came up in our discussion about the fines collected and in the enforcement piece, sharing that information, that being a portal. That it was the only substantive platform right now for that. So I wrote that down just to revisit it and at least express that interest from the board. And then, of course, those decisions, have to be, they're made above my pay grade, and, I'm comfortable with that. So, but we'll at least relay that information.
For those on the board that may not know what the NMLS does, it's kind of like a credit bureau of regulatory agencies throughout the country, not just collection agencies, but surveyors or barbershops or whatever it is. They just group all the. Tennessee's got a particular problem with an agency in New York that's not paying their fines and costs. That goes on the NMLS report, and then when that agency wants to renew his license in New York, they get on there and type it, and they say, "Oh, this guy's not paying his fines to Steve Harb there in Tennessee," and it really gives us, I think, an excellent enforcement tool to get these things done.
I believe when I returned from our meeting, our first meeting, that's when we first, at NACARA, when we went there in Seattle, the end of 2017. So I believe in April I gave a summary of NMLS, and I believe it's on the minutes. So if,
Yes.
as a refresher, if April 2018, if you wanted to look at that, revisit that, it's there and memorialized.
And just to follow up on the chairman's remarks, that may be an interesting thing to know. If we've got $8,000 or whatever the number is of uncollected fines, how much of that is owing, if we know, by entities or outfits or individuals who are licensed in another state? If it was the majority of it, that would be an interesting thing to know, because it would, to your comment, Director, it would certainly increase the likelihood that that amount would ultimately be collected at some point.
Right.
If there was this reciprocity in reporting through NMLS.
Exactly. And the state of Tennessee already participates with NMLS and some other of the programs. What's one of them that they do?
Oh, it is. That's the Department of Finance.
Department of Finance.
They deal with the mortgages,
Right.
and
Right.
with the payday loans over there in Tennessee Tower. They're using MLS now.
But we're already plugged in. We just need to plug in this department with them and go from there. And I don't know how our new administration feels about it. Our last administration didn't want to do it.
Question on a similar topic with different. What you've explained is if we send, I'm going to talk about Tennessee licensed agencies. Obviously, if you're unlicensed, you can't pull their license. But a Tennessee licensed agency, if they don't respond to a fine or don't sign a consent order, formal hearing to do anything with that. However, under what grounds do we have to renew a license? Somebody doesn't respond to us in Tennessee, their license should be flagged in Tennessee, and every 2 years when it comes up for renewal, no, don't renew it because they didn't respond appropriately to an action. I mean, I don't know how many that would be, but if you have a Tennessee agency that was fined and didn't pay the fine, and we didn't want to go to the effort of a formal hearing and go through all those hoops, can we not flag their license so that when they renew or attempt to renew?
I would have to defer to legal about the implications of that. Process-wise, we could flag a file, but as to the implications, to their property rights, that
We don't have to give somebody a license.
Right.
I mean, we're not required to give them a license if they apply.
And I will say, to my knowledge, we do flag those if they have an outstanding fine, and when they come up for renewal, we revisit that complaint. We let them know that there is an outstanding fine there. If they pay that, and then at that point we have no reason to deny it. But if they are not going to pay it, the board, it is within your authority to refuse to renew that license.
One thing that I would say would be problematic would be that unlicensed activity, though. Like 2017, out of 1, 2, 3, 4, 5, 6, 7, 8, 9. Out of 14 complaints in 2017, looks like 6 of those were unlicensed. So
State or out of?
I don't have that information based on the report, but that's something I can look into based on Mr. Holden's comments, and I will do that. But yeah, 6 of those. So it's a big share of that.
Still, any agency that doesn't respond to a fine or a penalty notice from us, instead of us having to go through the hoops of a formal hearing, to me, collecting the money is not as important as somebody who ignores the rules. And if they ignore the rules and don't pay a fine, consent order or not, we flag their account and/or send a notice to them saying, or bring it to the board that upon your next renewal, you will not be renewed because you don't comply with the Tennessee rules. I mean, if you don't comply with the rules, why do we license them?
And I think that is the purpose. So that of when we do flag it, I don't have the numbers in front of me, so that's why I'm kind of moot on that issue. But that typically is either resolved or addressed, and of course Aisha can speak to that as well from the licensing side of that before they get a now. And then that's why we also added in the agreed citation for the they're voluntarily retiring their license if they don't make that payment on the agreed order. And that was, of course, added in our last meeting, effective since then, and approved by the board. So I think that was a practical step. I think that was very helpful in that regard. Something I hadn't thought of before then, but apparently, I thank council for making that recommendation, and of course the wisdom of the board to see that how useful that would be. But I imagine we're going to see a lot of I think that's also a stick as well, because folks that want to continue to do business, if they can't get renewed, to your point, or they lose their license for non-payment. Now, we're assuming those are the actors that want to do what they're supposed to do. Those that sort of can't either get served, or we can't, they're out of state or can't find those folks if they're unlicensed in particular. That becomes a little bit more challenging. So that's the piece we have to kind of look for. Whatever may be available to us resource-wise to address that. But I think we've already made some moves in towards dealing with the renewals and with the that are currently licensed and have been fined.
Does the property rights for the license expire when the license expires?
Right.
Okay, so we don't have to renew them as
Correct.
property rights.
All right. Unless there's any other comments, we can move to the legal report then.
Okay, I'll just read the number and then the corresponding complaint number, and then at the end, any discussion, then we'll have that at that time. Number 1, 2018-07-8771. Number 2, 2018-06-5001. Number 3, 2018-06-5021. Number 4, 2018-06-6561. Number 5, 2018-06-6901. Number 6, 2018-06-7471. Number 7, 2018-06-8331. Number 8, 2018-06-9411. Number 11, 2018-07-3301. Number 12, 2018-07-4981. 13, 2018-07-5331. 14, 2018-07-12. 15, 2018-07-8301. Number 16, 2018-080911. Number 17, 2018-081691. Number 18, 2018. 19, 2018-054691.
Questions?
Chairman, Council Director, can we look at number 13 for just a moment on that list?
Yes, sir.
I wondered if the respondent in that instance was somehow exempt from the licensure requirement.
How does a debt consolidation program work? Is that like, it used to be Consumer Credit Service or something like that? Is that,
I'll let Aisha chime in here. She's our expert, subject matter expert for that. That's one of her responsibilities. So she gets in the real nitty gritty, gets her hands in the dough on that one.
State of Tennessee doesn't recognize it as debt consolidation. They look at it as debt management, where everybody's consolidating their debt and they broker a deal with the creditor to make those payments over a certain.
okay, I see what Josh is saying. Are they even a collection agency if they're a debt consolidation or a debt, what did you call them? A
Debt management
debt
company.
management company?
I don't know the details of that case, but I usually send the exemption statute if I see something different than a normal agency would apply for, and they would tell me, oh, we don't fall under this exemption, so we want to continue to get the license.
And I may be mistaken about the facts, but I understood that the respondent was not the one offering the debt consolidation program. They were an unlicensed debt collector, as I understood it. If that's accurate or not,
And that's what I would just double check, and that may have been one where that
the larger concern, as you're looking for that, the larger concern I would have is that if they are an unlicensed debt collector, then I would be concerned about the recommendation to close it without some sort of
Sure.
penalty, or at least a warning.
I'm just making sure that I didn't misidentify the respondent as, like an original creditor versus a third-party collector, and that may be what I did, but trying to see if there was any correspondence from the well, I think that going back and looking at the complaint, it looks like that the respondent would be attempting to collect a debt as a third party. $500 authorization for a formal hearing and $500 civil penalty.
I think that sounds more like it if the board agrees. Unlicensed activity. We don't know whether this company's in Tennessee or not.
Or person.
Let's look at the address. The responding individual is out of state.
Any other questions on number 13? Not. Steve, do you have any that you want to bring up?
No, oddly enough.
What's wrong with you?
I'm good.
Josh, you okay with everybody else?
Yeah, other than number 13, I don't know if we need a motion on it or not, but I would suggest that we take up addressing the recommendation on that one. And it sounds like council's already going to do that, but I don't know if we need a motion on it or not. But if we can have a...
We can do it, sure. We can do it all at once with the amendment that number 13 was the board has decided to authorize a $500 penalty and formal charges if necessary. So with that in mind as the motion, is there anyone that would motion to approve this with that amendment in place?
I would move to approve with that amendment, yes.
Do we have a second? All right, we have a second. All in favor then?
Aye.
All right. New business. Administration and doesn't have anything, and to my knowledge, legal doesn't either. Is there anything that the board would like to discuss? I think we covered some of that in some of the director's reports. So,
Continuing comment about licensed agencies that don't properly respond to us. I know that's a narrow band, but even if there's just one or two, I know the numbers are mostly unlicensed, but if one or two agencies don't respond to us on a penalty or something we provide to them, we really shouldn't renew their licenses.
I would agree with that.
License renewal comes up, that license renewal should be brought to the board as opposed to automatically approved through the process if it's flagged for that.
Typically, if something like that remains unresolved, then Aisha and I will have that conversation. So we don't get a lot of those. And you can imagine with 14 in 1 year, how many of those folks, when with 6 of those being unlicensed, would actually come up for a renewal. You know, so I don't know that we're getting a lot of it, but it's a good point and something that,
One or two bad eggs.
it's still enough.
That's still-
It's worth our consideration. So I'm gonna look at, make sure that, that we do have a firm process in place. But we do have flags that we are utilizing, and until that's resolved, they're not getting renewed. But I just want to make sure that there's no, cracks. So we'll take a look at that and revisit to make sure there's no cracks there. But thank you for your comments. Other than that, sure. All right. Do we have a second in that regard?
Second.
All right.
All in favor of adjourning, say aye.
Aye.
Thank you, gentlemen.
Thank you.
No, I had to drive too far for it.